So we've got folks from the Atlanta metro area and as well from all the way in Savannah and up north as well, Athens, etc. That's great. Again, this program is going to be a commemoration of the Voting Rights Act in Georgia, as it's turned 60 years old, but we're also going to talk about some other subjects. Beth, how are we doing on attendees right now?
We're up to about 43.
43. Okay. Well, I'll tell you what, it's six after. We're going to go ahead and start and get the program rolling. So again, my name is Ken Lawler. I'm the host for this evening, and we're going to start by kind of reminding you what this event is about, and we'll introduce our two guest speakers. So when we first started this event, we were going to commemorate and we still are going to commemorate the Voting Rights Act, which just turned 60 years old in August. But we've added a special topic which we think people will be interested in. It's going to be a short introduction, short update on what we call the gerrymandering war between the states. I imagine that everybody on this event is aware of what's going on in Texas and California and Missouri and who knows where else. We are trying, frankly, to keep it out of Georgia for now. But we'll have a brief introduction to that topic, although it's not the main topic for the evening, but we would be remiss if we did not mention it. Okay. So I want to introduce our two guest panelists now, who are with us tonight. Let me just make sure. Beth, you have them spotlighted, I assume.
Let me do it real quickly.
Yeah, let's just spotlight. So, joining us from the Brennan Center, the Washington D.C. office of the Brennan Center, is Dr. Kareem Creighton. He manages the center's affairs inside the Beltway and leads programs that include a new organization-wide project focused on the American South. So, Kareem, welcome to the South today. He's an established scholar on the intersection of law, politics, and race. He has served on law and political science faculties across the country and authored more than 2 dozen publications that explore the connections between race and politics in representative institutions. He is the substantive architect of a first-generation video game. I didn't know that, Kareem. You've been holding out on us about redistricting. We want to play that game sometime. And he's also a digital content creator who integrates the theoretical and practical aspects of civic participation to engage the broader public. So, Kareem, welcome and thank you for joining.
Thanks for having me.
And we have Rahul Garabadu, who is well known in the Georgia region here. He's a civil rights attorney. He was formerly with the ACLU of Georgia and the U.S. Department of Justice, believe it or not. So he's an insider, right? Um, while he was with the ACLU, he was directly involved in litigating the Georgia redistricting cases that were won in 2023 that resulted in improved legislative and congressional maps. He was then an assistant U.S. attorney in the DOJ, working on public integrity and civil rights. He is now in private practice with Crevlin Horst. So welcome to you, Rahul.
Thank you. Great to be here.
Great. So our program this evening is going to be an overview of the Voting Rights Act at 60. I'll start with giving a brief history of the act in Georgia, and then we'll turn it over to our panelists, Kareem and Rahul, for their perspective on where are we now and what are the challenges and the outlook that we have to go to, right? I want to mention that when I talk about the history of the act in Georgia, I want to give a shout out to two key volunteers who were behind the scenes in this event. Kimberly and Bill Hearn stepped up, and I challenged them to collect a lot of statistics and data about how the Voting Rights Act has helped Georgia. They did a tremendous piece of work, and I'm summarizing it in the briefest way possible in a short presentation here. But thank you, Kimberly and Bill Hearn. I hope you're on the meeting. Thank you for all the work you did to prepare the materials for tonight's event. So thank you very much. So I'm going to go through the briefest possible history of what is a momentous act in the history of civil rights in the country. Very, very brief overview, kind of from the beginning up to the early 2000s. And then we're going to have Kareem and Rahul give us their perspective on what's been going on kind of more lately, and particularly in Georgia. So just to step back to the beginning, right? Why did we have the Voting Rights Act in the first place? Well, if you look at the Georgia political environment post Civil War and Reconstruction, right? In 1868, Georgia elected the first group of 33 black members to the General Assembly, a milestone event. Shortly after they were elected, they were expelled, but they were reinstated, having had to go to court in Georgia and getting the Georgia Supreme Court to rule that they were eligible to serve. So again, it's kind of indicative of, the way things were back in the day, right? But then once Reconstructed kind of fell apart after the 1870s, um, they had there were a lot of threats and intimidation against these folks, and unfortunately, in 1907, the last of the 33 had to resign from the General Assembly, and there were no more blacks elected until 1962. So it was a very dark period for civil rights in Georgia, and in particular for voting rights among folks of color, right? So that's kind of a little backstory. We entered the Jim Crow area here, and in the Jim Crow area, we had all these things that popped up to prevent participation of minorities, especially blacks, in politics, right? There were poll taxes. There were things called grandfather clauses, where if you happened to have been a voter prior to the Civil War, you could vote again. Well, guess who that benefits? Certainly not the folks who were in slavery at the time, right? The Democrats instituted a thing called white-only primaries, where you only could vote in the primary if you were a white voter. But at that time, it was a one-party state. So if you didn't vote in the primary, you basically didn't have a vote, right? You could get good character endorsements if you were a black person, but guess who you had to get the good character endorsement from? A white person. This was just there was just so many different blocks, so many different obstacles were put in the way of voters. Literacy tests, probably you've heard of these things. Complex registration procedures. I'll share a couple of those in a second. There was a thing called the county unit system, where the representation in the Georgia General Assembly was by counties, and that tended to weight the rural counties in Georgia way above the urban counties where all the population was. And then, of course, just throughout this period of Jim Crow, there were a lot of threats, intimidation, and violence in general, right? So that's the environment we're in. Um, this whole thing was neatly summarized in one of the expert reports that was filed in the redistricting cases in 2022, where Dr. Jason Morgan Ward in the case said, "We had erected the most imposing array of obstacles to black voter registration of any southern state by the end of the 20th century's first decade." So by the end of the 1910s, right? So clearly there was a systematic mechanism in place to prevent participation of blacks in politics, right? So here are some sample voter registration questions. If you cannot read or write, all you have to do is answer 20 of these simple questions, like, in what state senatorial district do you live in? What are the names of the counties? Or what is the name of the state judicial circuit in which you live? I don't think I could answer that myself today, but this is an actual page from the questionnaire that the Hearns found for us, right? Or you could answer question 11. Who is the Solicitor General of your state judicial circuit, and who is the presiding judge? Like, anybody really would know this, right? So again, there was that you had to answer 20 of these complicated questions. And if you got them all right, fine, then you can register to vote. But this was nearly an impossible task for the average voter back then, and even today, I would argue, right? So again, we had this tremendous set of obstacles in the way. The Voting Rights Act of 1965 changed the game. It ushered in a brand new era, right? And basically, I'm summarizing a very complicated act, very high level here, and we're going to talk in some more detail. But basically, this act said we're going to prohibit any voting rule that results in the denial or abridgment of the right of any citizen to vote on account of race or color or membership in a language minority group. So that says if you were black or Asian or whatever, or if you're a language minority like Hispanics, if your native language is something other than English, you cannot be discriminated against in voting under the Voting Rights Act. The key provisions. This overall statement, and then it had specific provisions. It effectively outlaws all these things: literacy taxes, poll taxes, all the things you saw on the prior chart, right? It also effectively outlaws racial gerrymandering, because gerrymandering is a form of denying and abridging the right of any citizen to vote, right? It also required bilingual voting materials. There are certain counties in Georgia that do this today, following the Voting Rights Act. It also did something really important for Georgia and many other southern states. It set up this regime called preclearance. Preclearance meant that for a list of states, it was listed in the act, and there were criteria for being listed, but basically all the southern states, or the former Confederate states, were listed here. Um, you could not change any voting practice, redistricting line. You couldn't move a precinct voting place without going to the federal government to get the approval. That's between Section 4 and Section 5 of the Act. So the preclearance regime was set up so that the states who had a history of voting discrimination had to go through this. Now, you could still sue under the Voting Rights Act, but having the preclearance was like a deterrent. It basically said you're going to have to go get the federal government, the DOJ, or a federal court to approve what you are doing. So it had a tremendous effect of deterring some of these bad practices. And in 1973, a case from Georgia established the fact in the Supreme Court that redistricting plans were subject to preclearance. So we've had preclearance in place, although it ended, and we'll talk about that later. But from the beginning, redistricting plans were in fact covered by this preclearance regime that Georgia was part of. This act was extended many times. The original act had time-limited provisions, 5-year provisions for certain things. In 1970, the act was extended again for 5 years. In 1975, those provisions were coming due, 7-year extension, and it was added protection for language minorities in 1975. In 1982, upon when that extension was going to expire, the Congress enacted a 25-year extension. Again, this was under the Reagan administration. And an important clarification in the 1982 extension was that it clarified that the Voting Rights Act bans practices that result in discrimination, regardless of whether you can prove intent. So it used to be that you had to say, well, we can prove that you were discriminating by looking at, your motivation. But now, in after 1982, all you have to do is show that the practice itself appears to be discriminatory, that it has a negative effect on voters of color, and that was a big change in 1982. The last extension of the act was passed in 2006 for 25 years, so we are still living under this extension, and it included the pre-clearance regime, right? Passed overwhelmingly in the Congress. So the bottom line is, throughout the act's history in Congress, it has been a tremendously popular, very well-respected piece of legislation. I think people call it the premier Civil Rights Act passed in since the Civil Rights era. So with this, um, let's talk about the effects of the act, right? So just a couple charts that kind of talk about the progress that was made, right? So this graphic shows you in 30 specific counties in Georgia that were black dominant counties that had low black participation. The voting registration statistics you can see was down in the single digit percentages in 62, but by the time we get to 2004, we're close to 70. Obviously, tremendous progress in allowing blacks to access the polls and actually people of minorities, all of them, but because the primary group in Georgia has been black voters, we'll refer to black, but this refers to black and non-white as well. So again, voter registration leaped because of this, because of the Voting Rights Act. And the last chart I'll show you is that people were able then to elect candidates of their choice. Look at the total number of black folks elected in Georgia, elected officials in Georgia at the county, municipal, school, and the green line is the total, including state offices. And you can see that we've gone from almost nothing in the 60s all the way up to several hundred in 2001, the last date that was available in the statistics. So again, you could look at that and say, gee, the Voting Rights Act has done its job. It has enabled blacks to participate in voting. It enables them to get elected. It's all in all a pretty good success story, I would think, right? However, where we've arrived today is that this act certainly faces some challenges. So great progress, but there are some challenges. There are redistricting battles. There are restrictive voting losses that we have seen pass in Georgia, and U.S. Supreme Court decisions that, in fact, are threatening or maybe attacking the Voting Rights Act. They haven't, and they continue to. So at this point, I'm going to turn the program over to our experts to carry forward from this moment in time and talk about the current issues and challenges that we have and them to give their outlook. So I'm going to stop sharing my screen, and I think I'm going to turn to Kareem first and say, Kareem, your thoughts on what you've seen in the Voting Rights Act and where we are and how we're going forward. Just take 10 minutes or so and just give us your perspective.
Well, thank you, Ken, and thank you for making this opportunity to speak possible. I think it's important that we all be aware of the importance of the act. You very, dutifully went through all of the report card, if you will, of what gave rise to, I think, really was the most tremendous shift in politics in the country, pretty much in the history of its existence. And I don't think that exaggerates to say the point. Um, the Voting Rights Act really was a market shift in the way we did business in this country, although it was sort of an overdue commitment to a promise, as Ken pointed out in his presentation, that you know we have amendments to this country that were the result of a lot of very painful and frankly bloody conflict that tried to make clear once and for all that we were going to uh, give, you know, meaning to our that every person is equal in the 14th and 15th Amendments, and that, those two provisions read together assure that people, regardless of race, can enjoy all the privileges and rights associated with citizenship, which includes the right to vote. That promise, though, as Ken nicely described, for about 95 years really wasn't fully or even in some ways at all respected in the southern states, Georgia being among them. And I always like to start by reminding people that was 95 years. This taking, the scourge of enslavement out of it for the moment. After the time at which the 14th and 15th Amendments were on the books, a promise was made. The right to vote was simply on paper. It was not respected in most of the South, if not all of it. And Georgia was one of these places. So, what did it mean to be a person of color, particularly a Black person in this era? It meant that you had to abide by laws you didn't pass. You had to pay taxes to a system that wouldn't support you. You all surely know the story of you didn't get access to public services like schools and jobs that everybody else did for 95 years. So if you think of all the different elections that occurred during that period of time, it's meaningful. And so, yes, it absolutely was a tremendous shift in having a transformational piece of legislation like the Voting Rights Act on the books. But I also want to recognize how tremendously um, exclusive, right, the system was for a very long period of time. So we are at the 60th anniversary of the Voting Rights Act. It's important to know that is, again, and for all the reasons Ken described, massively significant in terms of the change it has wrought in the South. There's so many more people who have served in office, but more important than that, even so many more people who are participating in the system and seeing the system be responsive to them than certainly people during the Jim Crow era ever would have anticipated. But what that means in practice is, in some ways, even from the get-go, there was always opposition to the fact of having a Voting Rights Act, and it came in many forms. And, in its initial iteration, the Supreme Court of the United States, with, I always like to remind people, Justice Brennan, for whom my organization is named, um, they roundly rejected them and, kind of marched through the whole history, some of which you heard tonight, that it can't possibly be that Congress doesn't have the ability to once and for all stop what is a serious deficit in our democratic system. Well, that pushback in 1965 in the case called South Carolina versus Katzenbach was pretty roundly rejected, and things moved on. If you, are a person who studies history or you went to law school, you usually kind of tell that story and say, well, and yes, that's the story, that's the law we have today. Unfortunately, I think we are in an era where we're seeing a renewed life given to the pushback against the Voting Rights Act. I just want to briefly talk about why in this moment it is quite scary. Ken mentioned the last time the act was renewed, the pre-clearance system, it was renewed by a Republican Congress and signed by a Republican president. It had never happened before in the life of the Voting Rights Act. It had been bipartisan, but usually driven in part or whole by Democrats. There was a Republican, Reagan, who signed it in 1982. But in 2006, George Bush controlled the White House. Republicans were in charge of both houses of Congress, and they passed it pretty, significantly. There were very few elements of opposition, but definitely there were groups that spoke out against it. And unfortunately, a lot of them at the time were Republicans. And what we saw after that was, I think, and a march toward an argument to say, yeah, we always accepted the Voting Rights Act be on the books, but we want to return to some of these challenges that we thought actually had a lot of points of concern for us. And largely it was fueled by some of the same elements that pushed it in 1965, going through 1982 to now. And what you saw shortly after the act was pushed, there were cases brought that challenged whether or not there should be a Section 5 of the Voting Rights Act, whether preclearance should be a system that assured that states didn't backslide. And the court, which had changed dramatically, as many of you know, since 2006, with many more conservatives, gave a lot more consideration of those arguments. In a first case out of Austin, Texas, the court said, well, we think the act should stay on the books, Section 5, but we have some questions. And they saw I think it's fair to say they invited further consideration in future cases. One that came out, unfortunately, of Alabama was the answer to that invitation that said, look, we think the time may have passed for this very fulsome application of the law. And in 2013, the Supreme Court looked at the state of Alabama and a lot of other states who said, look, maybe it was okay in 1965 to have these extra protections to say you can't, adopt new laws without federal approval when they had to do with voting. And the court said, well, yeah, we agree that maybe if that was okay in 2000 in 1965 and 2013, well, we got a black president now. How could it possibly be that we still have race discrimination? Did everything I could and briefs to the court to explain to them that notwithstanding the black president, there were clearly elements in local and state elections that showed a lot of the discrimination was still present in the South in ways that it wasn't in other places. So there was definite reason to have targets put in certain areas to say we need extra protection to assure that new laws didn't discriminate. The court said, nope, that's not what we see. We see that there's a concern about equal dignity of states, something that to date has never really been fully theorized. And they said, fine, we'll allow now states to legislate on their own without the scourge of federal oversight. And what we saw, and this is important to note, was Justice Ginsburg, who's now deceased, said at the time, you're saying that things have gotten better, but you're not acknowledging the fact that they got better because of Section 5 preclearance protection. And what we saw without Section 5 preclearance protection, the very thing that Justice Ginsburg predicted, which is it's going to continue to roll back and get worse. We recently put out a report that showed that the very states that were covered under Section 5 got worse. If you measure what we call the racial turnout gap, the gap between participation of African Americans and people of color compared to white voters has grown. And it has grown around the country, to be fair, but it's grown faster in the places covered by that previously were covered by preclearance. And so to us gives very clear evidence that the loss of preclearance has meant a drop in political opportunity to participate for African Americans and people of color. And I don't need to tell you that in terms of data. Many of you know that shortly after Shelby was put on the books, many people adopted legislation right out of the box to try to grab back political power. Well, that's sort of the march that we've seen since then. And I'll get today to talk a little bit about one case, because I know time is short, where we're seeing now a point where actually, even in Shelby County, the Supreme Court at that time wasn't willing to go. They said, we're going to say that there shouldn't be Section 5 enforcement right now, but that's okay. You should not worry if you're concerned about the possibility of discrimination. You still have Section 2 of the Act. And under Section 2, you can go to court in a traditional fashion, sue when you see a discrimination, an act of discrimination in a law or practice. Well, what we are now seeing is, surprise, not even 10 years later, this assault has now turned from Section 5 to Section 2. And you see all over the country, but starting interestingly in Indian country and the Mountain West, you see cases brought that challenge things like whether or not individual plaintiffs can bring a case under Section 2 of the Voting Rights Act to attack discrimination. That is something heretofore no one ever thought. Even the people who didn't like the Voting Rights Act in 1965 all understood that private parties could bring a lawsuit. The new theory is well, only the Justice Department can do that. And I don't know if you noticed that the Justice Department has taken a very different view of civil rights than anybody has ever seen in the past. And that's including Reagan's Justice Department. So what they want to make clear is that the court should say only the Justice Department should give the ability, should have the ability to bring lawsuits, denying individual voters an opportunity to have their day in court. And now we have a turn to another assault right out against Section 2 to say, well, yeah, we know Section 2 is on the books. We know why Congress adopted Section 2, but we just think it's too onerous for us. It creates racial entitlement, some would say. And therefore, we don't like race at all. That's coming out of a case out of Louisiana. And I'll say this and then stop. The irony upon irony is the state of Louisiana was the state that gave us Plessy versus Ferguson in 1896 that basically ushered in Jim Crow. And now they're making the argument with a straight face to this Supreme Court to say, we just don't think race should be anywhere involved in our system. And just like affirmative action, we should get rid of this in the sort of effort to root out discrimination. Never mind the fact that Section 2 has had such a great impact, not just on sort of redistricting at the state level for Congress, which is what this case is about, but really in local government. If you look at county commissions, city councils, boards of education, all these places where people have government very close to them, what you've seen because of Section 5 is the creation of new and different election systems that take great account of not just race, but all the other factors that traditionally affect how people think about state and local policy to craft solutions that are more open to people of color than before. And it has had a dramatic increase not just in the number of people who were elected, as I said, but the number of people who participated in our system. And so we at the Brennan Center wrote a brief to the Supreme Court in this case, Calais, Louisiana versus Calais, making the argument that you can get these arguments about Section 2 and get lost in the congressional seats and all of that. But don't forget the fact that there are a lot of communities in in the country. We have 3,000 and about 3,100, in fact, different counties in our country, and tens of thousands of small local jurisdictions that have been dramatically improved because of the application of Section 2. So what we're really hoping for, we'll see on October 15th, is the court to say, all right, look, maybe this has gone too far. It is a very different court, as I said, even from 2013, which was not a great court, and certainly different from the one that Justice Brennan sat on. But what we know to be true is that the Constitution has remained the same. And so it is our hope that we have a fulsome argument that reminds the court of the truth of what the 15th Amendment stands for, and really what the Voting Rights Act allows the 15th Amendment to make real for the public. So I'll pause there, but I appreciate the opportunity to talk about a law that has had such a dramatic impact on the place that we all call home.
Kareem, thank you very much for those remarks. And obviously, you've been a key player in a lot of the cases that have been involved. Let's turn the floor over to Rahul Garabadu, who's also been involved in this in deep in the weeds, but he's a great speaker. I just want to remind folks that we will be taking your questions from the chat. I also know that we are posting links in the chat to further resources from both of these gentlemen, as well as some other Fair Districts materials. Feel free to utilize those resources. But if you have questions, start putting them in the chat. We will be taking your questions very shortly. Rahul, tell us what you think. Where are we? Where are we going?
Sure, and thanks again for having me. And Ken and Kareem did a great job of kind of speaking very eloquently about the history of the Voting Rights Act, the important provisions involved. I want to focus my remarks kind of on the practical, on the ground considerations that I've had to grapple with as a voting rights litigator in Georgia. But first, I wanted to really hammer home the point that I think Ken and Kareem and I will be making throughout the night, and that is that the Voting Rights Act really is unique in the way that it tackled this problem. And to Kareem's point, it was long overdue, but it's hard to think of any other civil rights statute or really any other law in the books that dealt so smartly with a problem that had eluded kind of good solutions for so long. Because if you think about kind of you know, what a law does, often a law says, you're not allowed to do X act, right? But the Voting Rights Act was unique in the way that it not only banned discrimination in voting, which again was subject to a constitutional amendment, but it also evolved to kind of tackle the creative ways in which people were discriminating on the ground, right? So it would have been impossible to put down on paper, an exhaustive list of what exactly what exactly jurisdictions were not allowed to do when it came to discrimination and what they were allowed to do. But inevitably, what we have seen through the history of this country is that, you know, you attack one method of racial discrimination, another method pops up. So that was really what made the Voting Rights Act so unique in the way that it handled this problem. Um, so I want to talk to y'all about a couple of the challenges to the Voting Rights Act that we see on this anniversary of the Voting Rights Act. And Kareem kind of really noted that 2013 kind of started the sort of chipping away at the Voting Rights Act in earnest with Shelby County versus Holder, ending that pre-clearance regime that Ken and Kareem talked about that had been so effective in combating discrimination at the voting booth. But even in the last 12 years, to Kareem's point, we've seen that extended, that hostility to the Voting Rights Act from the court. So Kareem talked a little bit about the private right of action, which the Eighth Circuit, which covers 7 states in the United States, has effectively said that private litigants do not have an avenue to vindicate their voting rights under Section 2 of the Voting Rights Act. So that is the law of the land in those 7 states in the United States. So thankfully, other circuits have not gone that far just yet. Even circuits like the Fifth Circuit, which has been notoriously hostile to things like, voting rights, has not gone that far in saying that the private right of action for private plaintiffs to litigate these cases is no longer an avenue to vindicate voting rights. So there is some hope in that the private right of action, will stay on the books. Here in the 11th Circuit, which covers Georgia, Alabama, and Florida, there is currently a redistricting case that I litigated below that is now up on appeal where the state is asking the 11th Circuit to end the private right of action, which I want to also note that would contravene kind of the last 60 years of how litigants have used the Voting Rights Act. But there are judges in the 11th Circuit who have kind of weighed in on this already. Some who have cast some doubt on the voter Section 2 of the Voting Rights Act, private right of action. But there is kind of hope that they will not go so far as to extend the logic from the Eighth Circuit as well. I want to also talk a little bit about how Section 2 specifically of the Voting Rights Act, which is the most litigated section of the Act, in order to succeed on a Section 2 claim, um, even before 2013, that was not an easy task. You have to prove a lot of, so taking a redistricting case, for example, you have to jump through a lot of hoops to show that either a state legislature or where there are independent redistricting commissions, to show that they got it wrong. It is a very Byzantine kind of structure that you have to kind of go through. And there was a study out of the University of Michigan that showed just how many of these Section 2 cases have actually made it to the finish line for plaintiffs, where plaintiffs have actually succeeded. And that percentage, it used to be about 50-50. And that has declined steadily. And part of that reason is because, a lot of low-hanging fruit in terms of election practices that were discriminatory have thankfully been, corrected. And so it was easier to succeed on some of those early on. But part of that is also because it has become more and more difficult to make it out of kind of the Section 2, the various obstacles that lay in your way in proving your case as a plaintiff. And part of that is by design, right? Because um, you you need to have a good reason to overturn kind of democratically, the legislature, um, the way in which they've drawn, voting maps. Um, but part of that is because, substantively, these have just become more difficult cases. I want to talk about one other kind of very practical consideration that has made litigating voting rights cases very difficult in the last decade or so, and that is a doctrine called the Purcell Doctrine. Um, and that is not specifically, related to the Voting Rights Act, although a number of Voting Rights Act cases, it tends to pop its head. The Purcell Doctrine comes out of a case that was litigated in Arizona, and essentially the holding of that case that went up to the Supreme Court was that judges cannot make last minute changes to election rules, right? And the reasoning behind that was, pretty rational because, you know, elections are very complicated tasks. And, federal courts can't just step in, at the 11th hour and say, actually, the rules in which this election is happening, we're going to change it by judicial fiat. So good luck, elections administrator, who have been preparing for months and months you know, to administer this election. So it came out of a very rational idea. But that doctrine over the last decade or so has become a way in which states defending their election practices have used as sort of a cudgel to defeat any sort of elections challenge to an elections practice. And it's not based on the merits of the actual, law being challenged. It's just by saying, you know what, we're too close to an election. Federal court, you should not get involved in this. You can't get involved in this because it's too late. We got to go forward with this election practice because it would be too burdensome on election administrators to change the laws at the last minute. I experienced Purcell being wielded against my cases basically all the time. In 2021, when I was with the ACLU, we brought a case challenging the redistricting maps here in Georgia. We focused on the state legislative districts, but we were in a related case with a case that challenged congressional districts as well. We filed our case about 6 minutes after the maps were passed because we had been closely following kind of the maps as they went through the state legislature. So we filed basically as close as you could possibly get to when that law was enacted, passing the redistricting maps in Georgia. And we went into an emergency hearing before a federal court to litigate that in what was called a preliminary injunction hearing. And even though we moved at basically warp speed, and even though the judge in our case found that we had successfully shown that it was likely that the maps had discriminated against Black voters, he ruled based on a Supreme Court's ruling in Alabama that it was just too close to the election. And this decision came down in March of 2022. That was about 2 months before the primaries here in Georgia, which happened in May. And so we ultimately were successful in overturning those maps, but it took another 2 years because we had to wait an entire election cycle before we could litigate those. And so for one election cycle in Georgia, um, Georgia voters were voting based on maps that a federal court had said likely discriminate against Black voters, which is kind of shows you how Purcell has created this warped environment. So we will talk about redistricting and more, but I just wanted to kind of show how the voting litigating these voting rights cases has become so much more difficult in this environment as we celebrate the 60th anniversary of the act.
Thank you, Rahul, very much. Very, very, very good comments. I'd like to just ping you with one question, which is right now, which is um, uh, as you were very very successful in getting the congressional and state house and state senate maps, that group of cases in 2021 that added the districts for black voters in 2023. We're very happy to see that. That's the most significant action we've seen in Georgia in a long time. The cases are on appeal, right? So all those cases are being appealed. I think you mentioned it. Could you just briefly discuss why? What is the state saying that has the potential really to undo all that progress? That's what worries me. So can you
Yeah.
just address that?
Yeah, the appellate process has become a little convoluted. Both sides are appealing on different issues. So I'll try to summarize as clearly as I can. What the state is saying is that essentially the relief that the court granted, causing the maps to be redrawn, was not warranted by Section 2. That's one of their arguments. I guess stepping back, their broader argument is that they are also arguing that Section 2 has no private right of enforcement. So what we were talking about earlier in terms of what's happened in the Eighth Circuit, that individual plaintiffs, which the ACLU and other groups were representing, cannot bring a challenge under Section 2, that only the DOJ could do that. That's one argument. The second argument is one that Kareem alluded to, which was that um, you know, Section 2 is no longer needed because we have kind of solved the scourge of racial discrimination. And that echoes kind of the affirmative action type arguments, right? So there's a lot of quoting the decision in the SFFA decision from 2023, which got rid of affirmative action, saying essentially that we don't need this anymore. That's another argument. Um, and then on the other side, the plaintiffs in that case are appealing the remedy. So they are saying that more black districts should have been drawn because the way that Georgia remedied this issue was by cutting into other coalition districts, which we probably don't have enough time to get into the weeds of that, but those are essentially 51% districts that are not just, black voter majorities. They're coalitions of, black voters, Asian voters, Hispanic voters, all coming together to form a majority. So the plaintiffs are challenging it on those grounds. So that's kind of where the appeal stands. The cases have been argued, and we're just waiting on a decision now.
Okay, and my understanding is that the as Kareem mentioned, I think the case from Louisiana, which basically is claiming that adding black districts is crude discrimination in reverse, kind of turning the Voting Rights Act on its head, could be the precedent center. We can bring Kareem into this discussion too, but could potentially be the first thing that gets decided, which then tells Georgia what to do. I mean, right? Would that possibly be the case?
I think that's what most of the people involved with ongoing litigation expect. It's partly due to timing. Louisiana has had also a convoluted procedural claim. This actually is a lawsuit that started, well, years ago with black voters challenging under Section 2 the failure of Louisiana to create a second African American majority or an African American opportunity district in Louisiana. It only chose to do one. It really ran pretty close to the cases I had a lot of involvement with in Alabama, where the state just only drew one, should have drawn at least two that had a better opportunity. That case reached its conclusion after, Raul mentioned, the Supreme Court did it essentially all it could to stop the application of Section 2 in that case. It finally got to an end. And the Louisiana legislature was supposed to draw a map, and it chose one that essentially pursued some political ends of its own, and white voters sued. And so the weird part of this narrative is it's white voters showing up saying to the Supreme Court, oh, yeah, we've done that race thing. We're good now, right? The challenge, I think most people view, and by the way, that's under a different regime that another conservative Supreme Court came up with, this idea of racial gerrymandering, the notion that race can't be so predominant in the process of drawing maps that it crowds out everything else. Now, again, by all accounts, the reason Louisiana drew the particular set of districts that it did was for political aims. They wanted to privilege a person they liked and disadvantage someone that they didn't. That's not the only way they could have drawn this district. They could have satisfied the court's order another way. But this argument has sort of taken on its own lifespan. And frankly, it's hard to look at all of these cases, Georgia, Alabama, Texas is now making a version of this argument in ongoing litigation they've had. There's clearly a discussion about how to give the court the right theory to get the vote that they want. But we'll see whether the court itself acknowledges that. You definitely get indications in Justice Kavanaugh's concurrence in Milligan, the Alabama lawsuit, where they upheld Section 2 against pushback by the state in that case. And Kavanaugh sort of raises this question of, well, I don't know that I'm all that comfortable in the long range with the way Section 2 operates. And basically, it's a call and response. He's made the call, and now I think a lot of people are out responding. We'll see what happens with him and other people on the court.
Okay, great. We're going to transition to Q&A from the audience. I'm just going to mention one thing that we were going to spend a minute here on this redistricting war between the states issue, which is not a voting rights act. There's some intersection with the Voting Rights Act, but everybody's aware of what is going on in the country right now with Texas redrawing their map, California threatening to redraw their map. I think Missouri's now in the game. It's becoming a hot mess, basically, right? So I'll say that we fair districts are going to hold another town hall on November 10th. I'll put the date up at the last slide here, but please mark your calendars. November 10th, we're going to have a town hall specifically on the issue of mid-decade redistricting, which is the practice of changing the maps between census cycles, which is what all these people are doing, right? To change the map between census cycles, and it's always done for political gain. So right now, Texas and California, all these states are getting publicity. People should know, and we did a town hall on this a few years ago, and I think there's a link in your chat to go view that one that said, you know what? Georgia does this too. It's just quieter. We have lots and lots of evidence of damage, and frankly, we're trying to ban this practice. And so, our organization, Fair Districts, has taken the position that says we understand why California is fighting back. We understand that Eric Holder, who's the head of the National Democratic Redistricting Commission, said, well, maybe we should take our guard down for a few years and just kind of fight the war, fight the battle so we can win the war. That is not our stance. We are staying on the good government side here as Fair Districts, saying this practice should be banned. What's right for Georgia is to not do this anymore. That'll be one of our key pieces of advocacy. Kareem, Roll, anything you wanted to say about the war before we go to the questions from the audience? I know we have a few good ones out there.
Yeah, I'll just be brief. I'll just say two things. I appreciate your making it plain that this is a separate, related, but a separate argument from what's going on with the Voting Rights Act. And I say that because it's easy to get lost in the fight between D's and R's, and that is a fight that exists. Our country allows for parties to move forward, but really, that is a story about the lack of national standards. And what you have when you don't have a sheriff in town is everybody kind of going for their own. And that's what we're seeing here. This Voting Rights Act question really is, in my view, a much more fundamental piece of unfinished business that the United States has never fully seen through. And that is, again, making good the wrong that I think it started with the Constitution fencing out groups of people because of race. And the way in which the court now, in my view, looks at race as being something that it can sort of turn it on and off like a spigot, really doesn't capture the way we've lived that. And I think, unfortunately, we now are in some of the challenges that we are in trying to help the court understand how you can't just sort of solve this by saying there's a point in time and we solved the race problem, we've taken a pill, and now we're cured. This is in my view, much more like having an addiction. We are addicted to looking at race for the purposes of exclusion. And I think the question that we have to recognize is, even if we've gotten better, does it mean that we can't relapse? In my view, that's the challenge. And if we can get the court to think about that in that mindset, including all the positives that we've gotten, it'll be helpful. Anyway, sorry for the sermon, but that I really appreciate that distinction.
I appreciated that sermon. I'll just add that this 2025 redistricting war is brought to you by this Supreme Court's decision in Rucho via Common Cause. Um, in 2019, the United States Supreme Court had a chance to weigh in on partisan gerrymandering and essentially said that courts cannot get into the business of partisan gerrymandering. It would be too complicated. Now, if you look at Section 2 jurisprudence, you will understand that there are a lot of complicated things that voting rights practitioners have to sift through. So it's not a great excuse, but I think we're seeing the effects of the court kind of abdicating from that fight. And one other thing I'll say is, I think if for folks who are not reading the briefs that come in these redistricting cases, um, it's very interesting to see after 2019, when states are defending their maps, they very baldly state in their briefs that, oh, this is not racial, this is not on the basis of race. We're just doing this to maximize our party's advantage. States attorney general's offices say that outright because you're allowed to do that under this regime where you are allowed to partisan gerrymander as much as you want to. The thing that gets complicated in places like Georgia is where race and party often get so entangled in ways that it's very difficult to extricate that. And it becomes a question of, is it race that's driving this? Is it politics that's driving this? And that's kind of one of the new frontiers in these redistricting battles under the Voting Rights Act that we see a lot too.
Yeah. Michael Beach has joined us to bring up some of the questions that the audiences have asked. And Michael, we have about 5 minutes. So
Yeah,
if you
yeah, I
a
was going to
couple
say
of
we got to
key
go
ones.
fast. I'm going to skip to, I think, one that really would help people think about this. Karen's asked about bring back the Voting Rights Act, but can you speak to some of the new legislation and that's been introduced and kind of how it tries to fix Section 2 section and pre-clearance and that sort of thing?
I can take a swing at it
Kareem, I'll open
briefly.
it to you first.
Sure, I'll take a swing. There are two pieces of legislation that I think can be responsive. Congress had the opportunity to pass both of them in the early 2020s and failed to do it. Came close, but one of them is the Freedom to Vote Act, which would, among other things, have banned mid-decade redistricting and banned partisan gerrymandering. The John Lewis Voting Rights Advancement Act. Was also on the books for Congress to pass. It again came close, not as close, but it would have really addressed a lot of the concerns about wanting more modern conceptions of where discrimination existed so that Congress could, in a much more fluid way, think through year to year or election to election changes that might reflect a need to change the application of the law. Again, that really opened up a lot of answer to what Chief Justice Roberts offered in Shelby County versus Holder. Those are two different ways in which you could think about regulating this out of control system. But they're probably, now that we've seen even more, they're going to be even, I think, more thoughts put into the mix.
Okay, great. Thank you. Another one, sorry, it's for Kareem again, is just helping talk about, you mentioned earlier why Black participation is declining as it relates to VRA and gerrymandering, and explaining, is that lessening participation due to the gerrymandering, or is it due to choice of voters?
Well, it's an important question. Here's what we know. Again, I think that's, as a social scientist, I'm interested in that question. I think it's hard to say that the choices of voters alone is driving this answer. And the reason we say it is, if you look at the places where the gap has grown the fastest, that is this gulf between white voters and voters of color, it's happening in the exact places where preclearance used to do some work. Now, that also means, it turns out, in a lot of these states, they have engaged in pretty heavy gerrymandering. So we also know that gerrymandering has typically limited choices, and that tends to drive down turnout. So, if you're asking me in what doses each one of those has had an effect, I can't quite tell you that. But I can tell you that all of these decisions, including redistricting, that has led to more gerrymandering than before, all of that is more possible without both the national standards that limit partisanship from being used, but also without the fulsome application of the Voting Rights Act that would stop, at least provide some more public engagement, and also actual review of acts that are adopted by state legislatures before they go on the books. That's been the real challenge that we've seen. And so all those things contribute to, I think, a lessening of, enthusiasm on the part of a lot of voters to show up and cast ballots.
Yeah, I'll
Yeah,
just add one comment to that, which is we've been looking a lot, Michael and I, at the lack of competition in Georgia, for example, with the way the maps are drawn. The maps are drawn to be uncompetitive. Voters get turned off. My vote doesn't matter. Why? California's voter participation in the 24 election went down 9%. Why? Because they know other states going to vote for president. So you turn voters off when you through gerrymandering make their vote not count, basically. I mean that's one of the
yeah, I
effects.
mean, essentially 6 out of 236 General Assembly seats are competitive in Georgia. That's just not good for the state.
Right.
Yeah. Yeah. Can I make
Last,
one
oh,
brief
go ahead.
point,
Yeah,
just briefly,
go
just to
ahead.
say, in Georgia, we actually did a study on the districts that were created because of court intervention under Section 2. What we found was actually, compared to African Americans outside of those districts, voter participation among African Americans was better. That is Georgia, Alabama, and Louisiana. So again, if you take all of this evidence, it's hard to deny that fulsome application of the law, as rightly described, has a positive impact on participation.
Okay, great. Can I
We have
take
time
one
for
more
one more,
question?
I think.
One
We
more,
just
I think, is just uh, can we think about any cases challenging the VRA Section 2 precedent excluding private citizens from standing before the court? Anything is trying to challenge this Eighth Circuit VRA ruling?
I think in the appellate argument that I was mentioning with going on with Georgia's maps right now, the plaintiffs are very strongly arguing against the state's argument that Section 2 has no private right of action. So we are seeing that argument play out through that case right now. And I think that's kind of the flashpoint of that argument here in Georgia.
Last comment from Joyce is just, and Joyce came from Louisiana, just saying they couldn't even get, when they were trying to register people of color to register, because they said their vote just didn't make a difference the way things were set up.
So I know we've run a little bit over. If there's a couple other questions, Michael, we could probably tackle them. I just want to remind people to fill out the evaluation. I know it has been posted in the chat at least once. We really do want your feedback on this program and future programs. You have any other ones, Michael, you want to
Yeah,
cover?
just one question. It's kind of complex, but for both of you, really, is thinking about this Supreme Court decision that federal courts can't deal with partisan gerrymandering. If the Voting Rights Act said this is about result, not intent, and race and partisan is so strongly correlated, how do we look at that decision? It doesn't make sense to me.
Yeah, and I'm happy to take this question first. I mentioned earlier that one of the arguments that's playing out in a lot of places right now is kind of like a chicken and egg question of, is it race that's driving party, or is it party that's driving race?
Right.
And um, there's kind of some circular arguments being made there. But in places like Georgia, um, now I think racial polarized voting is going down in general. But there are, when you look at this jurisdiction by jurisdiction, district by district, there are a lot of places in Georgia and the Deep South where they're still kind of inextricably linked. And that is kind of the new frontier of the battle on to your point, Michael, if this is about if we are administering a results test and the result of looking at party is resulting in dilution of the vote for Black voters or other minority voters, then isn't that one and the same? And it's too early to say kind of where that argument is going. I can say in our redistricting case, at least at the district court level, the state tried to make that argument and they didn't win it. We'll see kind of where that goes, but for now, at least, we have been able to show that where race and party are intertwined, you can still show racially polarized voting, which is what Section 2 of the Voting Rights Act is designed to address.
Okay, great. Thank you. Oh, you're on mute, Ken.
I want to thank Kareem and Rahul for coming tonight. You guys are the top notch. You are the experts in the country at this, and to have you come to Georgia and help us understand what's going on has been great. I'm just going to close with a couple of points here. One is that, look, we would appreciate audience's support. We have two organizations that work on this. There's the Fair to Six Georgia Foundation, which does all of our research, education, communication, and community programs. We are a tax-deductible charity, a 501(c)(3), or Fair Districts GA, which supports our legislative advocacy and lobbying, which is not tax-deductible. If you go to fairdistrictsga.org/donate, you can choose which way you'd like to support us, and we absolutely would appreciate your support. It's been great in the past, and there's a lot of work to be done here, a lot of work, and we would appreciate that. We will have another town hall on November 10th. Please mark your calendar. It's after the election, after the municipal election and the PSC election. Everybody should vote, obviously. But come back and we'll talk about mid-decade redistricting, and we'll maybe give an update on the war, and we'll talk about Georgia more specifically in that light. Follow us on our website, which is being redesigned, Facebook, Instagram. We appreciate your support. So I think we'll close the meeting and thank everybody for their participation tonight and our audience. And again, thank you to both of our speakers. Appreciate it, guys.
Thanks so much. Appreciate it.
Thank you so much.